talk. I wish we had more people here, but obviously there are a lot of other things going on campus today. So thank you for making this your choice to spend lunch with us today. As you probably know, the Federalist Society is a group of conservative and libertarian academics interested in the current state of legal order. And it's founded on the principles that the state exists to preserve freedom and that separation of governmental powers is central to our Constitution. And what we've tried to do specifically in this chapter here, what I've tried to do is just really bring a marketplace of ideas and open debate on a lot of issues, want you to hear as much as you can before making any kind of a decision about any legal issue. So that being said, I'll introduce our speakers just very briefly, and I encourage you to give a little bit more on your backgrounds when you come up. But the topic today is parentage rights, and Professor Collette is from St. Thomas College of Law in Minnesota, and she's going to discuss some of the legal kind of sticky issues as far as rights with modern reproductive technology, and I'll let her go a little bit more into that. But and then after that, we're going to have a panel commentary with Professor Parness and Professor Boudreau. And Professor Collette's going to speak for about 25 minutes. Then we'll have kind of everyone, as far as our speakers, engage in some conversation, maybe stimulate some questions from the audience. So if you have any questions, that'll be the time that those can be addressed. And we really just want discussion and get some ideas out there for everyone. So one final thing, logistically, we will have a hard break at 10 to 1, and there's another class in here at 1 o'clock. So if you could please stay seated until 10 to 1, I promise that we'll be out of here right at 10 to 1. Without further ado, are you ready?
I am.
Professor Collette? Perfect. Welcome. Thank you.
Let me begin by first telling Sarah publicly, thank you for being so patient. This has been a remarkable week. I was on a plane yesterday and the day before and the day before, and I thought today would be easy, and my flight was late, and then the rental car place said, oh no, we won't have a car for an hour and a half. So I think I'm supposed to be here because of the way everything had to work exactly. But because of that, the commentators have not had access to this outline, and so I apologize to them. As academics and as experts in the area, most of this they're going to be familiar with. The only question will be the ordering and my premises. And I'm really excited to have the comments because in particular I've cited to a couple of your professors' work in my own work, and so it's wonderful to share ideas. My thesis is somewhat controversial, and let me begin with the premise that one of the great debates that we have in American culture today is when does human life begin, or that's the way it's typically formulated. In reality, the real question is when will the law protect a human being? The Eighth Circuit in Planned Parenthood versus Rounds decided the question in the context of the South Dakota case where the legislature said that prior to an abortion, a woman must be told that abortion ends the life of a separate, unique human being. Now, I'm not here to talk about abortion today, but abortion is one of the major influences on other sort of procreative or reproductive questions, and so we have to at least take account of it. In the Rounds opinion, the en banc court said, Planned Parenthood has presented no evidence to dispute the truthfulness of the statement that abortion ends the life of a separate, unique human being when defined as a member of the Homo sapien species. All right. So as a scientific biological fact, no one in rheology books, etc., do not dispute when any discrete human life began. It began at the moment of fertilization, which is different than implantation and may be different than conception. And all of this is important for the embryo cases, so bear with me as I sort of walk you through this. Fertilization, of course, is when the sperm and the egg meet and the egg matures sufficiently to accept it. Implantation occurs when that zygote, pre-zygote, although that's a John Robertson from UT term that he used in Davis v. Davis that was completely disrespected in all of the bioethics literature by doctors after that. But nonetheless, implantation is when it takes in the woman's body. All right? In abortion jurisprudence, we have two other important time periods. One is viability. Viability is a moving target, as Justice O'Connor noted as early as the Danforth opinion. In the case of Danforth, they assumed it was 23 to 24 weeks of gestation. In Japan today, it's 20 weeks. In the United States, we've successfully had 20-weekers survive, and this is a really hot point right now because of different legislation that's passing through different courts. Arizona, the United States Supreme Court just turned down a cert petition regarding 20-week abortion bans. Again, that's not my topic, but to give you sort of the background. So we've got fertilization, implantation, viability, which could be clearly 24 weeks, and then birth. So when should legal rights attach? And how do we work those legal rights out? Well, it will, those of you who know any of my work, it will come as no surprise to you that I think human life begins, as the Eighth Circuit held, at fertilization. But then the question becomes, how does the law deal with that? So the thesis of the paper I'm working on, that I'm excited to present here and have comments on, is that when we're dealing with ex utero embryos, the IVF case, all right, when we're dealing with an embryo that is outside the woman's body, so nobody's pregnant, all right, nobody's pregnant at this point, all right, then I think it is always in the best interest of that embryo to be allowed to continue its development through birth. If we are serious about that being a human life, there are not many instances, at least where we don't have some sort of lethal anomaly, where we wouldn't say it's in the best interest to continue development. So I think when we're looking just at the best interest of the embryo, it's always in its best interest to develop. That interest, standing alone, may not be sufficient to answer a legal question, but it is sufficient when combined with a genetic or intended parent seeking to implant and nurture the embryo to birth. And I believe those two combined interests should always prevail, absent a showing of parental unfitness on the part of the parent who wants to implant. Now, what do I mean by genetic versus intended parent? Today, you can have 6 different individuals who have some sort of legal claim to parentage. We were beginning to talk about the Uniform Parentage Act. You can have a minimum of 6 individuals. The FDA is now considering a proposal where it may move to 12. But right now, you can have the man who wants to be a father but not physically capable. The woman, typically his wife but not always, who wants to be a mother and not physically capable. The oocyte or egg donor who doesn't want to be a mother but is happy to have her eggs used by other people. The sperm donor who, at least in this context, doesn't want to be a father but happy to have his sperm used by other people to create a child. The surrogate mother who will gestate the embryo, and in many states, her husband, when she becomes pregnant, will have some legal claim and some obligation related to any child born of her body, and we've not caught up yet, distinguishing the child that is an implant from another couple intended to another couple, etc. So you've got 6 people here, all right? I've limited myself to the intended mom, the intended dad, the egg donor, and the sperm donor. Any of those 4 who say, I want to continue development of this embryo, I believe their interest combined with that of the embryo should trump, and any objection from the other 3 should be disregarded unless there is a showing of parental unfitness. What could such a showing be? Well, one of the bioethical debates that we're having are savior siblings, a phrase that we see in the literature. What's a savior sibling? I bear a child who has some sort of disease, perhaps leukemia is where the first case came up, and I want another child, not for the sake of another child, but for the sake of perhaps having a marrow donor for my first child. Thus the phrase, the savior sibling. Now some of us would debate, well, that really doesn't make someone unfit if you want a child not for the sake of the child, but to use them for the benefit of another child, as long as you're committed to loving and caring for the second child. But there's also a case where children have been adopted for purposes of creating sexual opportunities for adults. I don't think anybody in this room would debate. That one's out of bounds. We're done. You're unfit, if that's really your history. And in fact, I was once sitting in court where a child was being removed from the custody of a father. We were terminating his parental rights. And he looked at a judge and said, "That's fine, I'll just go make another one." I think an adjudication of unfitness in other settings you might win on that one. All right, so that's my exception. But absent those sorts of circumstances, either any of the two genetic parents or either of the intended parents ought to be able to bring the child to term. Now, what do we do about the obligations that flow from being a parent? Notwithstanding any contract provision to the contrary, because now we've sort of come to the point that we allow the parties to negotiate this in a contract that's usually written by the fertility clinic. We could argue that it's a contract of adhesion. The terms are set by the fertility clinic, the couple take it or leave it sort of thing. But nonetheless, that's how it defines, that's how we most often define these rights. Notwithstanding any contract provision to the contrary, an intended or genetic parent shall be relieved of all legal and financial responsibility for the cost of implantation, nurture, and childbirth, not creation. If the woman's gone through an intensive drug regime in order to create the oocytes for development, etc., then she ought to be able to continue to share in her husband or her boyfriend's health insurance to the extent there are financial division on that. But going forward, implantation, gestation, and birth, if he, she, or they provide written notice of their objection to the creation and implantation to all other interested parties, including the fertility clinic, so they know, all right, the genetic parents, and the intended parents. So everybody's got to know, and it's got to happen. That notice has to happen prior to fertilization of the oocyte. In other words, a woman has the eggs harvested, begins to have second thoughts before the embryo has been created. She can say, "We're done." And the husband can go ahead and have the embryo created and use it for his purposes, but not imposing any financial or legal obligation. This is actually the law in Texas to some limited degree. I represented a wife who she and her husband were unable to conceive children. They went to the fertility clinic. She went through the drug regime and had a pretty rough time of it, but nonetheless, they were able to successfully generate 12 eggs. He went into the bathroom with a Playboy and generated sufficient sperm. Some would argue that there's a little difference in the burden there, but nonetheless, they then created the embryos. But on the eve of the fresh implantation, which has the best chance of success, embryos that have never been frozen have the best chance of success. On the eve of that, the husband turned to her and said, "I'm just not sure our marriage is going to make it. I don't think we ought to do this." He was prophetic, as you might imagine, all right? And they didn't make it. But there would not been one single implantation attempt. The agreement with the clinic provided that all remaining embryos would be frozen, but there was a presumption that there would be the fresh implantation. By the time the divorce hearings were occurring, my client was now 47 years old, the woman, and we had medical testimony that established that she was incapable of creating a child through any other means that would be biologically related. She was infertile by this point. The man, on the other hand, had the capacity to create additional children, one of the great cosmic unfairnesses in life. So, in this case, the trial court awarded my client the embryos, disregarding the contract provision that said upon divorce they would remain frozen, essentially, based on the fact that there was an assumption, mutual mistake, that there would be a fresh implantation attempt that did not occur, that was evidenced by the contractual terms. And secondarily, the burden to my client in giving up her rights to those embryos was far different than the burden to the husband. On appeal, the Court of Appeals in Houston, Texas, ruled that the right not to procreate trumped my client's right to procreate, and the husband's desire to have the embryos destroyed should be honored. We appealed to the Texas Supreme Court, who declined to hear the case. We then took the case on cert to the United States Supreme Court. I don't even think that qualifies as a Hail Mary pass when you're coming out of an intermediate state court. But nonetheless, we threw it, and they threw it right back at us and said, no, thank you. We then went to the Inter-American Commission on Human Rights and had similar lack of success. But that gives you a context of why I care about this, all right? So let's talk about what are the legal consequences to men from male participation in behavior that is procreative in nature. Hopefully you will. First, any man who provides sperm to a sperm bank, it will, as part of that agreement, be relieved in most jurisdictions of any obligations related to children that are conceived through the use of the sperm. This is just part of the deal. Now, we are seeing growth in Europe of a movement to not allow anonymous donations, so the child that's conceived will be able to identify the sperm donor. But in this country, we've not had much success with that argument yet. So the one way that a man's reproductive material can, if you will, get into the stream of commerce with no legal consequences to him is to use a recognized sperm bank. It doesn't work if you have a private agreement where the male and female enter into an agreement that the male will act as a, quote, sperm donor only through a consensual sex act. You don't have to go down to the clinic. We'll just do it here. I'm doing it as a favor for you. But we have a signed agreement that you will not seek paternity, etc. In that case, the courts have said, we don't care about your signed agreement. The right of that child to have paternal support is paramount. So don't be suckered, no matter how official the document looks. The courts will not respect it. Nor will she be foreclosed, the mother, in asserting the rights of the child. The male consents to and engages in unprotected sex. You're a father, congratulations, get your checkbook out. The male consents to and engages in sex with defective self-protection. He thinks he's fine, no child will be conceived because he's using a condom, but guess what? The condom has a hole in it. Condoms only have an 85% effective rate according to the FDA. Well, again, congratulations, here's your cigar, get your checkbook out. All right? The male consents and engages in sex with a woman who has negligently or falsely represented that she's infertile. Well, let's just begin with the definition of infertility. We don't really know when people are infertile. The doctors say 2 years of unprotected sex with no pregnancy. Then they're going to presume you're infertile and they'll begin doing the testing and figuring it out. But we don't really have a precise measure. Think of, perhaps, people you know who believed they were infertile, adopted a child, and before the child made its way back from Europe, guess what? We're having a baby! All right? So infertility is very hard. So she doesn't even have to be telling a lie. She may honestly believe she's infertile. But absent a hysterectomy or some sort of surgical intervention, don't trust it. Again, congratulations, Dad. Get your checkbook out. What about engaging in sex based on the woman's representation that she's using contraception? These are called the contraceptive fraud cases. And there are plenty of them where the court absolutely believes that the woman lied. And they say, congratulations, get your checkbook out, Dad. All right? We simply don't accept that. Because we know that sex, even when contraceptive is used, can create a child. And even the most effective contraceptive, used perfectly, which almost no one does, is only 98% effective. Okay? Again, centering on the best interest of the child. My favorites when I'm talking about this. A man consents to and engages in oral sex, not contemplating that this could in any way result in a pregnancy. The woman has a condom in her mouth, collects his sperm, and without his consent impregnates herself. Now, I actually explain this opinion under the "you're too dumb to win" category, which there are, and if you want to be a trial lawyer, recognize when you are in that situation. Because One of the questions asked at trial to this young man who was visiting both of his elderly parents in the hospital when a nurse came and offered to help relieve his stress in this manner, was asked, why did you do this? And he said, well, I'm a guy. What else would I do? I think this is a case of you're too dumb to win. You might think he's too dumb to be a dad, but he's not too dumb to write the check. He lost. Or the male ejaculates while unconscious because the female stimulates him, and she becomes pregnant. Rape under any definition I know. Congratulations, Dad. Get your checkbook out. A minor male consents to and participates in sex with an adult female who is charged with his care. Statutory rape in the jurisdiction at the time. Guess what? 14-year-old child, 32-year-old woman now has 18 years of child support because it was voluntary even though it wasn't legally consensual. Congratulations, Dad. Get your checkbook. I see a lot of return to abstinence happening in the room right now. All right, so, and then finally, male is husband of female who agrees to serve as surrogate for embryo created through the use of another egg. If the woman successfully is able to preserve custody of the child, either because the intended parents no longer want the pregnancy, perhaps there's been some minor disability diagnosed during the pregnancy, or they simply have changed their mind and she's willing to let them out of it, the husband will be legally presumed to be the father. So out of all of these 10 cases, there's only one instance where a man can avoid paternal responsibility to the child, and that is the use of a sperm bank. Now let's compare that to women's obligations. Oops, sorry. Female provides an egg to an egg broker, no responsibility. Male and female enter into the same agreement that she'll be the egg donor, perhaps for a gay couple, through a consensual act. She can keep the child if she chooses to. The court will not enforce that agreement. She can abort the child if she chooses to. The court will not enforce any agreement to require an abortion. Female consents to and engages in unprotected sex, defective self-protection, male's negligent. In all of these instances, the woman has control once the embryo is in her body. She can continue the pregnancy or she can terminate the pregnancy based upon her own determination. This is where the abortion rights come in. An adult female who wishes to terminate a pregnancy for any reason and at any point in the pregnancy in the majority of jurisdictions, or a few after viability, which is presumed to arise at 23 weeks, can terminate for any reason and there will be no naysaying. As early as 1976, which was reaffirmed in 1996, a male has no legal right to notice of the female's intent, even though he's the father of the child and would have paternal responsibilities if the child were born, nor does he have any legal right to stop or delay the abortion of the child with the father. Men have zero rights. This was a big issue with Justice Alito's confirmation because he thinks at least husbands ought to have rights as long as you have expansive exceptions where the woman claims that the child wasn't his or that she's the subject of domestic abuse, etc. The only female who does not have an absolute right to an abortion is a minor, and then she can be subject to parental notice or consent laws, which would only require that a parent or a judge be involved, and only if she is immature and it is not in her best interest to involve a parent could she be stopped from having the abortion. So virtually, women's reproductive rights in this instance are almost absolute. Men's reproductive responsibilities are almost absolute. Now, the men's part doesn't bother me because I would like to see the woman's situation be that if you voluntarily engage in behavior that creates a new life, you have committed yourself to a 9-month process of nurturing that child, after which you are free to leave it at the hospital or in accordance with any other baby Moses law, which in Nebraska goes all the way till they're 18. You can leave those troublesome teenagers right there at the fire station. All right, but contract, there is nothing like this in contract law, right? You enter into a contract to create an embryo for purposes of gestation and birth of the child. If one of you gets cold feet, like the husband did in my case, the courts ignore it, even though there's clearly been partial performance and promissory estoppel should exist. And I think bargaining in good faith should exist. Doesn't matter. What about the concepts of property law? Well, if we treat the embryos as property law, we know that generally co-owners of property, one cannot interfere to the rights of possession and use by other co-owners. At least you get partition in kind, and my client should have at least gotten half of the frozen embryos. They weren't interested in any of that either. And if they're children, as I think they are, just teeny tiny children, then child custody is certainly the person who wants to bring them to term. But what we see in every case in the United States, and increasingly in cases out of the EU, is that the party who wants the embryos destroyed prevails consistently every single time. Let me close with the EU case, which I think is even more compelling than mine, although I think it's hard to find one. In that case, a cohabitating French couple had decided they wanted to conceive children and had difficulty. Cohabitation is even more common in France and more long-term than it is in the United States. They went to the clinic, they agreed that they would create these children. In fact, the contract provided that the woman would have the right to them. She then underwent chemotherapy that rendered her sterile, as anticipated. Her boyfriend left, and when she sought possession of the embryos for purposes of bringing them to birth, the court said the man's right to avoid being a father trumped this woman's right, who was rendered infertile, as was anticipated at the time of the embryo's creation, to have a biologically related child. I think this is a great injustice. And I think it perhaps poses the question, have we converted what used to be the right to choose into the right to live? Thank you.
Do you gentlemen both want to come up, or do you want to come up one at a time? It's completely up to you. And even if you want to just pull up a chair and we can have conversations, whatever you'd like to do.
Well, I'll say a few words.
Oh, Professor Federalist, then, thank you.
Not very many, because I think this kind of presentation is important to allow you the conversation. First, let me say, although I've been doing a lot of work in the area of parentage, my work really is outside the scope of Mr. Collette's presentation. I know a bit about it. It's outside the scope in part because these are, at least to me, rare cases. And I'm much more concerned with the prevalent cases, which are things like assisted reproduction, outside the scope of statutes, things like the increasing number of unwed mothers, things like the failure to use the voluntary paternity acknowledgement process so as to have every child born with both a mother and a father at birth. Today there's about, 1.8 million kids born in this country every year with an unwed mother. Believe it or not, about a third of those kids, about 600,000 kids, are left without a father on the birth certificate. That to me is shameful. So I've devoted my attention to those areas. But let me say a few things about this more discrete area of parentage. First, I'm not offended by Professor Collette's
Radical views.
not radical, not unreasonable, but just contrary to prevailing U.S. Supreme Court precedent, Roe versus Wade. She doesn't like it. You know, I live with it, whether I like it or not. And I'm much more comfortable in talking about preconception pre-viability and viability, and combining all of those to what the U.S. Supreme Court did say in Roe versus Wade was the legitimate state interest in protecting potential human life. And I would phrase it that way. I wouldn't talk about when does human life begin. I would assume that human life begins at birth, as the Supreme Court, I think, did in